Hello Live Law viewers, welcome to Courts Today by Live Law, your daily roundup of legal updates from across the country. I'm your host Urvashi Chauhan, here to keep you informed and up to date. Let us start with the headlines before diving into the details. The Supreme Court has flagged ED's poor conviction rate in ex-West Bengal Minister Partha Chatterjee's bail plea. In the Lakhimpur Kheri violence case, the Supreme Court has sought accused Ashish Mishra's response on the allegations of him threatening witnesses. The Supreme Court has said that religious conversion only to avail reservation benefits without actual belief is impermissible and is fraud on Constitution. The Supreme Court has held that for offence of rape on false promise to marry, physical relationships must be shown to be only based on marriage promise. In the PIL filed by Air India urination case victim, the Supreme Court has questioned the union as to how they check passengers who get intoxicated in flight. The Karnataka High Court has called for higher penalty on pet owners who do not clean their pets' excrement in public parks. The Apex Court has issued notice to Delhi Municipal Corporation over demolition of Delhi's public library in Karol Bagh. On many occasions now, the Supreme Court has questioned the conviction rate in the cases filed by the Enforcement Directorate. Many accused under the PMLA like Aam Aadmi Party leader Manish Sisodia were granted bail this year due to long incarceration and delay in trial. A bench of Justices Suryakant and Ujjwal Bhuyan was hearing a petition filed by former West Bengal Education Minister Partha Chatterjee seeking bail in the money laundering case arising out of the bribery allegations in the recruitment of assistant primary teachers in West Bengal. He has been in custody since July 2023. His counsel, Senior Advocate Mukul Rohtagi, prayed for bail, highlighting his incarceration for over 2.5 years, him being 73 years old, and that there was no possibility of the trial completing soon. This is because there are 183 witnesses and 4 supplementary prosecution complaints. Rohtagi also placed reliance on Section 479 of Bharatiya Nagrik Suraksha Sanhita, which provides bail to undertrials after serving 1/3 of the minimum sentence, as the same has been completed in custody by Chatterjee in this case. Additional Solicitor General S.V. Raju, appearing for the Enforcement Directorate, said that a major scam was going on whereby jobs were being offered to undeserving candidates based on bribes. There was rampant corruption, he said, affecting more than 50,000 candidates. He said that co-accused Arpita Mukherjee has clearly told ED that money belonged to Chatterjee. ASG also said that Section 479 of BNSS was not applicable to him because of the gravity of the crime. Raju also feared that if released on bail, Chatterjee could try to influence witnesses. During the hearing, the bench also flagged the low conviction rates in the cases prosecuted by the Enforcement Directorate. Though the bench expressed an inclination to grant bail, the hearing was ultimately adjourned till Monday to get more details about the custody undergone by Chatterjee in the connected CBI cases. Stay tuned. Coming to a short update on the Lakhimpur Kheri violence case. The case relates to killing of 5 persons in October 2021 when vehicles of Ashish Mishra, son of former Union Minister Ajay Mishra's convoy, allegedly ran over a group of farmers who were protesting against the farm laws. 6 days after the incident, he was arrested. Last year, first in January, the top court granted him interim bail, and then in July this year, the bail was made absolute. Though various bail conditions have been imposed on him, an application was recently filed in the Supreme Court alleging that Mishra was threatening witnesses. Today, a bench of Justices Suryakant and Ujjwal Bhuyan of the Supreme Court has sought response from him regarding these allegations. Though Mishra's advocate, Senior Advocate Siddharth Dave, refuted all the claims, saying that they were meant to get attention from media and public. The court, however, said that Mishra will respond to the allegations formally by filing an affidavit. In another update, the Supreme Court has pronounced an important judgment with respect to persons who try to take advantage of reservation by showing false conversion of their religion. In this case, a woman born as a Christian claimed to be a Hindu while applying for an upper division clerk job in Puducherry and sought scheduled caste reservation. She contended that her father was a Hindu, mother was Christian, and later both practiced Hinduism. She also asserted that her family belonged to the Valluvan caste, and throughout her education, she was treated as part of the scheduled caste community, with her father and brother holding SC certificates. But the court noted that as per the report from a village administrative officer, her father was from a scheduled caste but had converted to Christianity. She was born in 1990, baptized in January 1991, shortly after her brother's baptism in 1989. On examining the evidence, the top court said that undoubtedly the woman professes Christianity and actively practices her faith by attending church regularly, and that she could not provide any evidence to prove otherwise. The Madras High Court had denied her scheduled caste status, against which she appealed to the Supreme Court. But the top court has now upheld the High Court's order and has said that religious conversion only for the purpose of getting benefits of reservation is a fraud on the Constitution and against the ethos of reservation policies. The court also said that scheduled caste benefits cannot be granted to persons who have converted to Christianity unless they can demonstrate with compelling evidence both reconversion to Hinduism and acceptance by their original caste. The menace of rape in India remains a serious concern. Despite laws being in place and widespread protests, shocking news headlines continue to emerge each day. At the same time, there have been numerous reports of false rape cases. In many instances, courts acquit the accused, finding no merit in the case of the alleged victim. In one such case, the Supreme Court has given clarity as to when a consensual sexual relationship can amount to the offense of rape on the false promise of marriage. The bench of Justices B.V. Nagratna and N. Koteshwar Singh of the Supreme Court was dealing with a quashing application of an accused. He wanted the FIR filed against him for rape of a woman to be quashed. He contended that their relationship was consensual and that the woman had filed the case only after he stopped giving her financial assistance. Whereas the woman, the victim who filed the case, alleged that he had forceful intercourse with her under the garb of false marriage promise. The definition of rape in our law defines it as a sexual act where consent is obtained through coercion, threat, or deceit. A promise to marry is considered a form of deceit if the promise is made without the intent of fulfilling it, leading the victim to consent under false pretenses. But in this case, the court said that it was not the case. The judgment authored by Justice Singh noted that in this case, the decade-long physical relationship maintained without consistent objection suggested consensual involvement rather than coercion. The court said that it was unlikely that the victim would have continued with the relationship for so long under a mere promise of marriage, also without any evidence of deception. The court observed that when a woman has maintained a physical relationship with a man for a long period, it cannot be said with certainty that such relationship was solely because of a promise made by the man to marry her. A woman may indulge in physical relationship with a man for reasons other than the promise of marriage. The court said that to attract the offense of rape on false pretext of marriage, it has to be established that the sexual relationship was based only on the promise of marriage and the consent was vitiated due to misconception of fact when the man refused to marry the woman. In the judgment, the court has also expressed concerns about increasing trend of lodging criminal cases against men after the breakdown of a consensual relationship. I am sure you remember the Air India urination case from November 2022. This was when a male passenger allegedly urinated on a female co-passenger in the business class of an Air India flight. The incident came to light when the victim filed a complaint, calling the incident highly traumatic. Initially, the airline handled the complaint internally, offering a partial refund to the victim, but did not register a police complaint. The victim later pressed for criminal charges, leading to an FIR being filed over a month after the incident, and with the accused arrested in January 2023. The 72-year-old victim in the incident approached the Supreme Court shortly after with a plea seeking directions to the Director General of Civil Aviation and airline companies to lay down SOPs and regulations to deal with incidents of passenger misconduct on board. In May 2023, the top court issued a notice on this plea. The case came up for hearing this week before the bench of Justices B.R. Gavai and K.V. Vishwanathan. During the hearing, the victim's advocate argued that after the Air India urination incident, the airline crew failed to offer her an alternative seat despite vacant business class seats. Additionally, the crew pressured her to settle with the perpetrator against her wishes. The counsel also suggested improvements to the existing DGCA guidelines referencing practices from foreign jurisdictions. Further in the hearing, Additional Solicitor General Aishwarya Bhati for the union said that a penalty of 30 lakhs was imposed on the airline and license of the pilot in command was suspended. She further stated that though DGCA guidelines and circulars to control unruly behavior of passengers are in place and airlines have their own SOPs, the union was ready to look into the suggestions. Interestingly, during the hearing, Justice Vishwanathan shared his own experience of a flight incident where two drunk passengers caused trouble. One locked himself in the washroom and fell asleep, while the other vomited outside. The judge then questioned union as to how they check the passengers who get intoxicated on flight. The ASG responded that she would submit the existing guidelines to the court and assured that any violations would be addressed appropriately. Bad pet parenting or not cleaning up your pet's excreta in public areas could now become a bigger concern for the people of Karnataka. Yes, this is because the Karnataka High Court has directed the state authorities to increase the penalty amount to be imposed on dog owners who or whose dog are found to be conducting themselves irresponsibly in treating and cleaning of the excrement of their pets in public parks. The order was passed by a bench of Chief Justice N.V. Anjaria and Justice K.V. Arvind while dealing with the PIL filed by an NGO that highlighted issues of uncleanliness caused by irresponsible pet owners and the failure of authorities to ensure cleanliness in such cases. This penalty amount, the court said, would be higher than that which is imposed on other class of people who breach cleanliness norms. The court said that while the pet owners have the liberty to take their dogs to the parks to roam around, other people who visit the parks also have a right to enjoy clean environment. And lastly, the Supreme Court has today issued a show cause notice to the Municipal Corporation of Delhi and the owner of a building that housed the Delhi Public Library in Karol Bagh. The notice has been issued regarding demolition of the building in 2018. A bench of Justices Suryakant and Ujjal Bhuya expressed concern over the circumstances surrounding the demolition. The court noted that some public-spirited journalists had sought to protect the library. They had approached the Delhi High Court in the year 2018 requesting to quash the municipal corporation's notices calling for the premises to be vacated. But the petition was dismissed by the High Court on 10 September 2018. Further, without giving even a breathing time to the tenant or other persons who were likely to be affected upon demolition of the building, the Municipal Corporation of Delhi demolished substantial part of the building on 18 September, that is 8 days later of the High Court's order, before lunch. And this was the same day when the top court stayed the demolition, directing that no portion of the property shall be demolished. The MCD has denied conducting any demolition. But the property owner claims that the demolition was carried out by the MCD's executive engineer and that he has photographic evidence of the same. Because of these conflicting stands, the court has now asked the parties to present their contentions by affidavits. For more information on the cases discussed here, please visit our website at www.livelaw.in. Your support means the world to us. So do not forget to like, share and subscribe to our channel. You can also support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month.